part heard in the matter of the Commissioner for HM Revenue and Custom and VolkerRail Plant Ltd.
Good morning.
Morning.
My lady, my ladies and my lords. You should have two things which we've handed up. I hope they're on your desk. One is the comparative analysis, which I will come back to because I was going to refer to that later. But that's in hard copy.
I think we were given that yesterday, I think, but anyway, never mind.
I think you were sent it.
I think we got it by email.
Yeah. Yes, I'm sorry. This is
sorry, that's right.
This is a hard copy.
Yep, thank you. Yes.
And the other thing is a case, which is one that might be familiar to some of you, which is the Hurst case in the Court of Justice. And I was going to start with that before I move on to NN, which is where I was going next. Because one of the points that my learned friend made yesterday was that the Swedish company in NN would not have a right of establishment that was being restricted in Denmark, and we say that's not correct. And fundamentally for the reasons that the European Court in fact identified in NN in looking at the second difference. But I just wanted to show you what was behind that. The principle that's behind it, which is a fundamental principle in relation to freedom of establishment, and you can get that from this case. Perhaps for my lady, this case concerned the UK system of partial imputation, which existed between 1973, I think, and 1999, and in particular. The aspect of it which was ACT, Advanced Corporation Tax, which was paid on dividends paid by UK resident companies. The idea was that that would then flow through to the shareholder and frank their liability to income tax at the basic rate if you received a dividend in those days. Now, within a group of companies, of course, dividends might be paid up in a chain of UK companies.
Yep.
Each of them would be in principle liable to ACT. However, to avoid multiple charges, there was a system known as group income elections, which allowed the company paying and the recipient to elect, if they were in a group, that the dividend would be paid free of ACT. The ACT would then be postponed until the final payment. However, that system only applied if both companies were UK resident. Within the UK system, you can see the obvious rationale of that. Sure. However, a German company complained, a German company which had a UK subsidiary and received dividends from the UK subsidiary, complained that it could not make a group income election with its UK subsidiary, and therefore was being treated differently from a UK company with a UK subsidiary. And that was what this case was about, and in the end the European Court decided that that was a restriction on the freedom of establishment of the German company, which was not justified. Right. And that resulted in a great deal of litigation in this country.
Yes,
so
I think,
I think my lord was involved in some of the fallout from some of that.
Yes.
And I think you were lucky that you were off the bench on the bench by the time, not on the bench when it ended.
I don't think I avoided it in time.
You avoided it, yes. But in any event, there's only one paragraph I think I need to take you to, which is the paragraph 41. Which states the fundamental principle. It's on page 1774. And it says Article 52 of the treaty constitutes one of the fundamental provisions of community law and has been directly applicable in the member states since the end of the transitional period. Under that provision, freedom of establishment for nationals of one member state within the territory of another member state includes the right to take up and pursue activities as self-employed persons and to set up and manage undertakings under the conditions laid down for its own nationals by the law of the country where such establishment is effected. The abolition of restrictions on freedom of establishment also applies to restrictions on the setting of agencies, branches or subsidiaries by nationals of any member state established in the territory of another member state. So the German company in this case was able to say, we're entitled to establish our subsidiary in the UK on the same terms as a national of the UK, in other words, a UK subsidiary. And that is an aspect, an important aspect of the freedom of establishment. And that would have been a complaint which the Swedish company could have made in NN. In fact, as we shall see, the court in NN does not identify,
Sorry,
it doesn't have to identify whose freedom of establishment is precisely.
But can I just understand that a bit better? Because I thought the point that was being made was that from the Swedish company's perspective, there was no distinction between setting up a branch or a company in Denmark because the same restriction applied. So
that's
I
right.
think that's the point being made. So how
Absolutely.
you address? Do you say that that addresses this?
No, that's right. But I thought the point that was being made was, because of that, the Swedish company had no complaint about its freedom of establishment being infringed. That was a consequence of that.
Yeah.
And if that's the argument, then we'd say that's wrong, that it would have an equal complaint. With the Danish company could complain and the Swedish company could complain.
I see.
And
So on the facts of an end, would you say that the Swedish company could complain in the same way that its Danish parent
yes,
could
exactly.
complain?
And indeed, it's a matter of no interest to the court whose freedom of establishment was being restricted. We shall see that the court actually refers to the group freedom. And that, my lady, is exactly the point that was made by the European Court, if you remember, when the argument was made that there wasn't a restriction because there wasn't a difference of treatment in relation to subsidiaries and branches. They then said, well, there is a difference of treatment of a different sort, which is a difference of treatment between the company with a Danish company, a Danish group with a Swedish company, and a wholly Danish group, because the wholly Danish group would not suffer from this problem. So that's a difference of treatment that they actually identified when we come to look at the decision. So we would say that this goes back to my point. If there is this principle that how do you choose which of the companies whose freedom of establishment is being restricted, that you focus on, if this home state, host state distinction is important, because certainly the court doesn't identify which company precisely has had its freedom of establishment restricted.
They do. The starting point for the analysis is to find a difference in treatment.
Yes.
Which is why in NN they do go.
Yeah. But the difference in treatment is between, looking at it from the point of view of Hearst, the difference in treatment was between a German company with a UK subsidiary and a UK company with a UK subsidiary. They were treated differently.
I see what you mean.
Yeah. And the German company or the Swedish company is entitled under the freedom of establishment to establish itself in the other country on the same terms as a national of the other country. This is all, of course, subject to justifications, which might come in later, as to why you can treat them differently. But at the level of whether they've got a right that is potentially infringed, we would say, in this case, both the Danish company and the Swedish company in NN had a right that was potentially infringed.
Okay, because the Swedish company could say, if I had been a Danish company.
I would, I'm entitled,
That's all right.
exactly, I'm entitled to establish myself in Denmark in the same terms as a Danish company. Yeah. So, with that point in mind, can we then look at NN? And it's in tab 4. We'll begin with the Advocate General, which is behind tab 72. And if I can pick it up, this is on justification, at paragraph 62, which is on page 899. And I think paragraphs 62 and 63 are quite important. Perhaps you could read those, but they are the Advocate General's analysis of Philips Electronic, and then his statement in 63 that it's difficult, based on that judgment, to classify prevention of double deductible losses as an overriding reason in the public interest.
I mean, that makes it clear that the Philips problem was absolutely at the heart of the analysis, as far as the AG was concerned.
Absolutely, yes. Yeah. Because he then goes on to say, perhaps the time has arrived to moderate these assertions made in the judgment, in the view of the fact that the EU legislature has paid special attention to the fight against double deduction since that judgment was delivered. And then you may, I imagine that you'll have read the following paragraphs already, but if you would like to just skim through them again, rather than me read them out, down to paragraph 74. So the Advocate General makes the point that although in some cases this is linked to the fight against tax evasion, he calls evasion, I think he probably means what we would call avoidance. It's linked to the fight against tax avoidance. That's not necessarily the case, and there may be it may apply in situations where, as he says, no intention to defraud exists. Possibly slightly less extreme. No intention to avoid tax exists, and I think there are two reasons for that. One is, even if there is no intention to avoid, it still has the result that the overall tax base, looking at the tax base as a whole, is reduced, because it is reduced twice with respect to the same losses. The other is, and that may be linked to it, the point he makes in paragraph 75, that it results in a cross-border group being treated more favourably than a wholly domestic group, where there is no possibility of a double use of losses. In any, as I mentioned yesterday, I think any rational domestic system would prevent losses being used twice within the domestic system. And that's the point in particular that is picked up by the European Court. You see in their judgment where they endorsed paragraph 75, or the point he makes in paragraph 75.
I mean, standing back a little, I mean, this is always going to be a problem or a source for, as it were, clever manoeuvres by companies in a cross-border situation, given the absence of a harmonized system of taxation. You have different systems of corporate tax in different countries, both in and outside the EU, which inevitably gives rise to asymmetries and potential double deductions, double taxation, and so forth.
Yes.
And at a high level, you know, double tax treaties deal with a lot of the issues which arise. But also at a perhaps more granular level, you get this, you know, the issues such as the ones we get in this case, where in perfect, no doubt, perfect good faith and so forth, you end up apparently getting a double deduction if the taxpayer's arguments succeed.
Yeah. Yes. Yes, there are situations where it's clearly been engineered, and there are others perhaps where it hasn't particularly been. It's just a consequence of the different tax system.
Yeah. But either way, it's inherently a bad thing.
Yes. Yeah. Exactly. For all the reasons the Advocate General has set out. So if you then like to just read quickly what he says about proportionality, which is on page 901, where I think he concludes for an application of what looks very, very similar to the Marks and Spencer's approach in paragraph 82. And he concludes it's for the referring court to ascertain whether that occurred in the instant case. And then if we move to the court, and I was going to start by looking, if we turn to page 906, paragraph 16, you can see that the court has, as it often done, reformulated the questions. If you recall, the questions were all in terms of how does Phillips apply, or similar variations on that. What they've done, what the court has done here, is simply reformulate it as to a straightforward question as to whether Article 49 precludes national legislation, and then there is a description, essentially, of the Danish system. That's fairly standard. You find that the dispositif in many European court cases will start Article 49 either precludes or does not preclude legislation of the sort, and then there's a description of the national legislation in the issue. And this is...
Yeah, I suppose the reason for that is precisely that the guidance has to apply across the community. So you want to, if possible, state the question in terms which are not tied to one particular country's legislation, even though the description effectively gives the game away.
Yes, exactly. I think it's keeping the proprieties that they are interpreting the treaty and not deciding the particular case. And then there are a couple of preliminary observations in general about freedom of establishment. And then he deals with difference in treatment. And this is where we have the two types of difference of treatment. You've already been through these paragraphs, but what the court says is, well, the Danish government is right that there isn't a difference in treatment of the sort that was identified in Phillips. However, there is another difference in treatment, and that's paragraphs 28 and 29. And that I would submit is really a reflection of the principle which I've shown you from Hurst. And that renders it less attractive, the exercise of freedom of establishment. It is, however, incompatible with provisions of the treaty only that concerns situations which are objectively comparable. And then they deal with objective comparability, which I will come back to when I deal with that. Yeah. And then they move on to justification. And you will see that they start by, the referring court asks whether it could be justified by the objective of ensuring a balanced distribution of powers of taxation or by preventing double deduction of losses. And the balanced distribution of powers, balanced allocation, is rejected in paragraph 40. This is a case just like our case and Phillips, where it's not a case where losses are being imported from other jurisdictions. It's simply a case of UK losses being set against UK profits. In this case, Danish losses being set against Danish profits. And then they turn to the second justification, the double deduction of losses. That's the one which is highlighted by the Danish government. And then they repeat, I think this is important in this respect, the court has already ruled that member states must be able to prevent the risk of losses being taken into account twice, Marks and Spencers and Lidl. So what they're essentially doing is ignoring, if you like, Phillips and going back to the line of cases which I showed you.
Or finessing it.
Yes, well, the line of cases before it, which all stated in unequivocal terms that member states must be able to prevent the risk of losses being taken into account twice. Yeah. And then they say in paragraph 43, in a situation in which a permanent establishment's income is taxed by two member states, it appears justified that the charges borne by that establishment should be capable of being deducted from the income in one another and the other tax systems in accordance with national rules. As I've indicated, that appearance may be deceptive, but in any event, they conclude that in this case that isn't the situation because of the double tax treaty. They're not being taxed twice because there is a credit being given, and of course that's exactly the same position as we have in the present case, where the UK-Netherlands treaty provides for a credit. And then they say in paragraph 48, paragraph 31.2.2 of the law on corporation tax is specially intended to prevent the group concerned from exploiting the same loss twice. In the absence of such a provision as noted by the Advocate General in point 75, cross-border situations would confer an unjustified advantage over comparable national situations, which a double deduction is not possible. The difference in treatment established by national legislation thus appears to be justified. So that we would say is a clear statement by the court, contrary, we would say directly contrary to what both the Advocate General and the court said in Phillips, that double deduction of losses, preventing the double deduction of losses can be a self-standing justification. That's exactly what it was in this case, because there only was one justification in play. And whether you can assume that they had in mind the whole of the Advocate General's opinion on this point, certainly they would have had it and it would have been part of their deliberations. What you can certainly tell is that they did adopt what he said in paragraph 75 of his opinion. And of course that is one of the reasons why this is a bad thing, but it does discriminate between wholly domestic groups, wholly domestic single companies, and multinational groups. And then they go on to consider proportionality. The difference in treatment must be proportionate to its objective, as recalled in paragraph 18. A rule such as that laid out in paragraph 31.2.2 of the Law on Corporation Tax would go beyond what is necessary to prevent the double deduction of a loss in the case where the effect thereof would be to deprive a group of any possibility of deducting the loss of a resident subsidiary in a cross-border situation such as that issued in the main proceedings. That might be the case, according to the referring court, in the dispute in the main proceedings. So they're stating it very much in the terms of the kind of Marks and Spencer's approach. Is there any possibility of deducting the loss? Since the loss sustained by the permanent establishment in Denmark and NN's Swedish subsidiary is in principle deductible from that subsidiary's profits, which are taxable in Sweden, it cannot be deducted from the taxable group profits in Denmark, pursuant to the rule laid down in 31.2.2 of the Law on Corporation Tax. However, in the case in the main proceedings, the loss is the result of the merger of two Danish branches in the group, and the choice made by the group, notice that the choice made by the group was permitted by Swedish law that the merger be treated for tax purposes as a restructuring of activities and as such not subject to tax in Sweden. Consequently, it would not be possible in practice to set these losses off against the Swedish subsidiary's profits. In a similar case, the national provisions at issue in the main proceedings, the consequence of which, according to the referring court, is to deprive the Danish group of any effective possibility of deducting the losses in the resident permanent establishment of its non-resident subsidiary, fail to have regard to the principle of proportionality. That principle would, by contrast, be respected if the setting off against the Danish group's profits of the loss sustained by the resident permanent establishment of its non-resident subsidiary were accepted by derogation from the rule laid down in paragraph 31.2.2. And I think we've looked at this. I think you should read this as provided that. That seems to be the French, and it makes much more sense. So it can be accepted by derogation from the rule, provided that the group has demonstrated that the setting off of the aforementioned losses against the subsidiary's profits is actually impossible in the other member state. I would think that the sense is just a not very good translation.
A mistranslation.
Well, that must be right, given what they say at 56, because it's a matter for the national.
Yes, exactly. I think it, and it does seem to be what
yes, because the
French
sense implies that they've concluded that, and in the next paragraph they're saying somebody else needs to decide.
Renko to determine whether that's the case. Yeah.
Sorry, could you just tell me again what the French was?
What was it? All right.
I mean, perhaps we can have the French text.
I can provide. Yes,
point,
yes.
yes.
I'm told that it's actually even clearer in the Italian and Dutch versions, which actually translators provided that. So So, but yes,
I'm not sure the Dutch version would help.
But
me,
the Italian,
but
Italian,
the Italian and the French
Italian and French would be
probably would.
Yes.
Please.
yeah,
So
okay, we could
that would be
we
great.
could provide that. But I think otherwise it doesn't make any sense, this
Yeah.
paragraph. As you say, it's for the referring court to determine whether that's the case. And you can also see in the dispositive in paragraph 57, if you just drop down to about 5 lines up from the bottom, however, Article 49 must be interpreted as precluding such legislation in the case where the effect of its application is to deprive that group of any effective possibility of deducting those losses from the group's overall profits. Where it's not possible to set off those losses against the subsidiary's profits in the member state and the territory of which the subsidiary is established, these matters being matters for the referring court to verify. And one can see the perfect sense in this context of asking that question, because if what is concerning feature is the double use of losses, if there is no possibility of the losses being used twice, then that justification loses its force. The justification of preventing the double use of losses. So you can see the logic of what the code is saying in those exceptional circumstances where it's impossible to use the losses. In this case, Sweden.
Yeah.
However, it isn't enough for the taxpayers to say, well, we chose to enter into this particular arrangement that meant that we couldn't use the losses. What they have to show is, leaving that aside, was it impossible to use the losses?
So making the election was itself if that's part of what makes it impossible, then it's within your own power.
That's a choice you've made. Exactly. And otherwise, if that were not the case, then there'd be no need to send it back to the national court.
Right.
Well,
they already know that they.
Okay, but you can read that in a number of ways. For example, that election might be something that could be withdrawn. There's a. Yeah. I was going to ask the broader question. You say the any possibility and effective possibility, I think you say, should be read with the M&S and subsequent cases on the M&S test in mind.
Yeah.
That isn't actually spelt out.
No, it isn't.
There's only a reference to M&S earlier in a slightly different context. And although you may say that the election is not good enough,
yes,
there may be other ways of interpreting that, such as if the election can't be withdrawn, for example.
Yes, I don't think this is an issue in this case, so it may not be necessary for you to decide that.
But the possibility test may be an issue.
Yes, it certainly is.
It is.
And well, if we're right that it's what the court says here, then clearly in this case it was possible to use the losses. In fact, we know they did.
Yes, so that may be not what the court had in mind.
No, well, we would certainly submit it was exactly what the court had in mind. It's looking at a case probably very like the kind of case of definitive losses in Marks and Spencer's. It's certainly right that in the other case law that we've looked at, which hasn't been directly a Marks and Spencer's case, they have talked throughout about definitive losses. The cases I've shown you. So they have been applying that approach in cases that are not straightforward Marks and Spencer's type cases.
Yes, you said those are included in the cases we went through yesterday.
Yes, exactly. Yes.
And just looking at it as a matter of ordinary language without the background, you're told the question is whether setting off the losses is actually impossible. That does sound as though a contrast is being drawn with something which is is asking you to look at the factual position rather than the legal position. Is that right, or a combination of both? Or and what if it's legally impossible? Because the law just simply says you can't. That's one thing. On the other hand, it might in theory be possible, but in practice be impossible simply because there is, there's nothing there in practice.
Well, I think yes.
Sorry,
and
I've expressed that very badly.
Yes.
What I'm groping.
I think it would apply if it was possible theoretically under the law, but was not possible on the facts of the particular case because the facts were such that it was impossible. Cases like where the company has ceased to exist essentially,
yes,
got rid of everything, that would be a case. Whereas certainly if you apply the Marks and Spencer's approach that we've shown you, the fact that the foreign law says you can't do it is not good enough.
Yeah.
Because that would be essentially importing the foreign law into the other state's law in. It's a case where it actually is impossible in the facts. I would submit is what they're referring.
So you say the election here is equivalent to the
It's indistinguishable. Certainly, if we were asking a Marks and Spencer's question, we would certainly say
that's a feature of the foreign tax law, and that's not good enough.
It's a fortiori case where you're able to elect to do it under the foreign law. So I suppose that leads to the question: where does that leave us in our case, if that is right? And our primary submission, you'll have seen from our skeleton, is that the UK legislation as it stood is easily capable of being interpreted in a way that would be in line with this approach.
Yes, so on your approach, you don't change. Is this your slightly modified meaning of deductible or allowable?
Well, we don't have any. There's no case law yet as to what it actually means anyway.
Yeah.
In the UK, so.
But your argument that it can be construed.
Easily construed.
In a way, without changing it to allowed or deducted.
Yes. Whereas there are more problems with changing it to deducted, which was the Upper Tribunal's answer. Because that is neither in line with the European Court's approach or with the language, obviously, of the UK provision.
So sorry, have I got this right around? I mean, you're criticising the Upper Tribunal's reading of deductible as deducted.
Yes.
But you're saying that the refinement you propose effectively in your cross-appeal skeleton is the right way to deal with the issue. Yes,
Yes, I mean, it is our secondary fallback position. But
yes, but
if that's not right for whatever reason, then...
Okay, so just to clarify, your primary position is not to adopt that fallback.
Our primary position is not, and it was in fact our position also, although I'm not sure it's recorded in the decision, but it certainly was our position before the Upper Tribunal that the legislation should be interpreted in line with this, what the court said. But the Upper Tribunal weren't keen on that, as you can see. So our primary position is the legislation, without really without any need to amend it. It's in fact perfectly arguable that that's what it meant in any event, but it certainly can be interpreted to mean this. So that, yes, and so it's got two advantages. One is it's in line with the language and the grain and the thrust of the UK legislation, clearly, and secondly, it's supported by what the European Court said in NN.
And what about the other possible lack of proportionality identified in the decisions? The point about it's fatal if any part of the profits is tainted, is probably the wrong word.
Well,
And you say, I mean,
I think that is the.
I mean, that seems to be a matter really of conventional construction. I suspect one can interpret that just to mean on a sort of pro rata basis, rather than not that just if £1 out of a million is somehow caught, then none of the rest qualifies. I mean, that would be a very bizarre, very, very draconian provision in a very convolutedly worded provision. It may be, as I say, just as a matter of ordinary interpretation. I might be able to make sense in a less extreme fashion.
Yes, the difficulty in this context is identifying this one, as you say, this £1, because you've seen what the court has said, that if the company is still going and has income, whatever amount, that is enough to say that you cannot say there is no possibility, and once you've said that, that's the end of it.
Yeah.
Sorry,
So
are we talking at cross purposes? I think I'm also referring to the provision in the legislation that says, that actually has the words to the extent that, I've got it in front of me.
I'm sorry.
The
Yes.
£10, let's say only £10 of the 20 million could, on any even theoretical basis, be usable elsewhere. I think that is a discrete point, isn't it?
If you're looking at it at the time and you can see that the only income they can ever have.
No, not income. We're talking about the losses.
But it's they need income to set against the losses.
Yeah.
It's the use of the losses by the. What we're looking at is it possible for the company in its state of residence to use the losses, and it can only use the losses if it has income. That's why they talk about. They say that if the company has
can we just look at section 403D because
sure.
I think we might still be talking cross purposes.
Sorry, I may have.
And I had thought that this was actually not a live issue on the appeal, so we probably do.
No, I think that's right. It's not. I think that is correct. It's not a live issue. And I was just wondering whether, in fact, there might be other. Anyway, one reason why it's not a live issue could be there's quite a straightforward construction, which would produce that result anyway, without going down and without having to do a conforming construction at all. But this may be a complete red herring.
Yeah.
So
It's
sorry.
the no part.
It's page 56. It's in bundle 1, tab 13.
It's the no part of the
Yes.
wording, isn't it?
So it's saying that is actually saying that if any part, essentially,
That's precisely the point.
Yes,
so,
if any part
so
of
let's say just £10
Yeah.
of a 20 million loss made by the PE
can be utilised,
could be used.
Yeah.
but only. I mean, you're taking a situation where we know for certain that it's impossible for anything more than £10 to be used. It's probably a rather unusual situation.
Well, not necessarily, because it could be the way that losses are computed, or different.
Well, if it was a matter of the foreign law, and we'll go back to that point, that wouldn't help you.
Okay, can we stick with the statutory interpretation?
Yes.
Just to try, because this is a point that both
it can be interpreted in line with
the Upper
with the Marks
Tribunal,
and Spencers.
the Upper Tribunal do deal with this point.
Yeah.
Yes. They say it's one of the, I think, is it 2 or 3 ways they identify in which the legislation is disproportionate. I mean, is disproportionate.
But that's assuming that they're assuming that I'm not right in what I say about the no possibilities
Yes.
approach. They're assuming that that's wrong because they didn't adopt that in its full rigour, if you like. They were saying, well, it can't be right that the problem is, you then have to make an assessment. It's quite difficult to know how you do that, as to how much, looking in the future, how much of this loss can be used, and you can't do that. This is the point that the European Court were making an EC Commission in the UK, that you might have to wait for years to find out how much of the loss actually ends up being used, because the company might go into liquidation 10 years later.
I think the difficulty may be that you're assuming as a starting point that M&S principles apply,
exactly,
such that the foreign law, the restrictions in the foreign law, which might mean that only £10 is deductible, are ignored. So I think that's the starting point for what you're saying, isn't it? Because otherwise I'm not really following.
That's exactly my starting
really
point. That's exactly what I'm saying, and I'm saying that if that is the European law position, then this legislation is in line with it, because the European Court would say, if you ask them, if you have a situation where the foreign company has a small amount of income, are they able to say that the legislation is not justified? And the answer would be no. They would say the legislation is still justified in those circumstances. That's what they have said.
Yeah. But are we correct in thinking that the point we're talking about at the moment isn't really, it isn't addressed really in your arguments, or very obviously in the grounds, though it's the Upper Tribunal deal with it. You say you don't really need to because you succeed.
Well, we do say that, I think we do say in our grounds that we have appealed against what the Upper Tribunal decided, and we say that you should apply the no possibilities approach is the correct one as a matter of European law, and that leads to the conclusion that the legislation is...
Yes. Yeah. So, but you do have a fallback. You've referred to it in the context of your cross appeal, and in that fallback, you would presumably modify that.
Well, it would be an odd situation if the legislation was justified and proportionate, which is our starting point, but then it was impossible to construe it compatibly. And we would say that you must be able to do that, and so that's a fallback, but it doesn't really, I have to accept, it doesn't really address the points that the European Court are making. But if you were to approach this in the same way as the Upper Tribunal, then you may be attracted by their approach, which is, I think their assumption was, well, there must be some, despite what the European Court said, it must be dealt with in a way that ensures that you get to a result that it's only the you don't lose everything just because there is some deduction in the foreign state. But we would say that ignores the fact that the starting point for all of this is the UK legislation, which does provision that, does say that. And then you're asking the question, well, is that contrary to European law? And if the answer is it's not contrary to European law because European law allows that approach, then that we would say that's the end of the question. You're not required to adjust the legislation to what you think might be a fairer system, if that's what you think, because there are competing interests, competing aspects to this. One is you might say, well, it's fairer if they only get restriction on their loss relief in relation to something that actually was deducted, to the extent it was actually deducted. But that simply raises the difficulty how you actually implement that. And the legislation that would be required to implement that would be enormously complicated, because you would have to take account of clawbacks of various types and various systems.
The UT interpreted it in line with what the statute actually provided between 2000.
For that period when it says
so.
that. Yeah. Well.
So it's doable. It's quite a separate question as to whether.
As to what it means. Yes.
As to whether that's
it has been changed back now. So maybe
interpretation.
Second
But you know, for 7 years or whatever it
had
was,
that,
it
yes.
did say deducted or allowed.
Yes. But it does raise a lot of problems.
Well, yes, we had to clarify what the result was in this case. So.
Yes. Well, the Marks and Spencer's litigation in the UK was all about how on earth you deal with this in situations where the company went on trading for years after. But that's not the approach of the European Court. It's much simpler. It's simply to say, well, you're entitled to have this kind of legislation, it's justified, but in a very exceptional case where it's just impossible to use the losses, then it's disproportionate. That we would submit as the approach the European Court has taken. It may be, when one is being realistic about this, it may be that they've rather repented of this unfortunate 100 words. I think Advocate General Cook referred to in one of the cases, which I haven't shown you, but she referred to all the problems that were caused by these 100 words that were in the judgment of Marks and Spencer's. But the court perhaps doesn't want to say we were wrong, but has simply restricted it to a very, very narrow compass. Unless there's any other questions on that, I was going to move on to a topic which I think is relevant to a couple of these aspects, which is the objective of section 403D(1)(c). And we say the objective is clearly to prevent the double use of losses in a particular situation in which it is problematic. I understand that it's said against us. Well, it's not. That is not the objective as regards European law, because it is not because of the other aspects of the legislation, which means that it's not being pursued rigorously enough for it to be an objective.
Sorry, just to make sure I did get that. You're simply saying the objective of the provision is to prevent the double use of losses.
Absolutely.
Whereas what's being said against
there's no other objective. Looks at the legislation in a broader way, or may look at the legislation in a broader way. Well, yes, I think what's being said is, well, because it doesn't apply to carry forward and carry back of losses.
That's the point the Advocate General was making in her opinion.
Exactly.
Yeah.
And her answer to that is, well, that's misconceived. That simply isn't a problem for the reasons that we've stated. I'll just come back to that briefly later. The other point that's made is it doesn't apply where you have a UK company which is a subsidiary of a foreign parent. Even if the losses can be used in the foreign jurisdiction, they're not restricted in the UK. And this is where the comparative study comes in. What we said is that is a situation which is much rarer than a situation where the losses can be used by the branch and by the company of which it is a branch. And you can see, first of all, why it's much more natural that the branch would be consolidated in with the company. That would be the prima facie position. Now, there are some states which do not do that. And I think what this analysis shows is that of the 30 EU and EEA states, 4 of them have the potential for a group relieving losses from a foreign subsidiary to their companies. And I think it may be 22 of them, have the possibility of the losses of a PE being consolidated with the company. So that's obviously a much more widespread practice.
I'm sorry, I haven't got that down in a way I can make sense of.
Right, sorry.
Say it a bit more slowly. 30 EE states 4 have the potential of group relieving.
The losses of a foreign subsidiary with their with a parent in their member state. So there would be a situation where
the losses of a foreign subsidiary against
can be set off against the profits of the parent in the member state.
yes,
parent in the member state.
Yeah.
Thank you. Yeah.
without having to form a tax unity or anything like that. There are some which allow you to form a tax unity, but then of course the profits are taxed as well as the losses. So
Yes.
different situation. And then
And you have 22.
22, I think it's 22, allow the losses, the situation that we have here, where the losses of the branch are consolidated with the results of the company in the other state. So the problem that section 403D1C is intended to deal with. And the important thing is, what is the test which the European Code adopts in deciding this question? And we would say, we say that the test is, and I'll show you a few cases, whether the measure is manifestly inappropriate to the objective, which reflects the fact that the member state is given a margin of appreciation in what they do. And we can see that, first of all, in a case called Swedish Match, which is in Authorities Bundle 4. Tab 75. And if you turn up page 935, and if you look at paragraphs 35 and 36, it's where the court states the principle. And this was then applied further in Vodafone, which is behind, by the Advocate General in Vodafone, behind tab 82. When it's page 1044. And you can see, if you look at paragraphs 115 to 117, That is in the context of tax. See here. And then also by the Advocate General in UBS, which is tab 84. And it is paragraph 99, which is on page 1088. Which is the opening of this section where he discusses it in a consistent and systematic manner. But then when you look at paragraph 116, which is the conclusion, where he states it in terms of whether it was manifestly inappropriate. So I think what they're looking at here is does this measure really have the objective that it seems to have, or is it actually a disguised form of discrimination, an attempt to prevent foreign companies or foreign individuals from access to the market in the member state? That's, I would suggest, is the thinking behind it. So it's only if it's clearly just a front, if you like, for a form of protectionism that you would say that the objective is not what it appears to be. But we would suggest on that basis that this provision clearly has the objective that it states on the face of it.
So is there an example of the court adopting this test in relation to the assessment of national legislation? Because this is an AG's opinion.
Well, the Swedish match was the...
Oh, I see, sorry.
Yeah.
Okay.
These are, although that wasn't in the context of tax, so I was just...
I thought Swedish match was about EU institutions.
It was, but it's then being applied by the Advocates General in relation to...
Yeah, but so my question was...
there isn't... yes, my answer is no, there isn't.
No, okay.
As we're aware.
No, but that's why I asked the question.
Yeah, sorry.
Okay. All right.
That brings me finally on this on the appeal to the question of overruling. Now, just to be clear, we say this only arises if you take the view that for whatever technical reason, Phillips is still binding on this court or on the UK courts. And I've already, obviously our primary submission is that NN is binding and has departed on this particular aspect from Phillips. I think I have to run through this relatively briefly. The relative provisions are in the Withdrawal Act, which is section 6. Which is tab 21 in the authorities bundle. And it's perhaps important to just note subsection 1 first. The court is not bound by any principles laid down or any decisions made on or after exit day, which I think is now IP completion day by the European Court. So decisions after are only persuasive, but decisions made before continue to be binding. And it cannot refer any matter to the European Court on or after exit day. Of course, that is I would submit, the reason why the courts are then given the power, certain courts are given the power to overrule decisions of the European Court. Because otherwise, given that there could be no reference made, the position of the law before exit day would be ossified in the UK. Even if there had been developments in the European Court after, it wouldn't be possible. This court, the UK courts, would be bound by the decision before, and they would not be able to overcome that by the decisions that took place after. So there is the power to overrule. Of course, it could be in other circumstances. It could simply be that the court takes the view that the European Court was plainly wrong in a decision that it made. But the context is more likely to be a situation where the law has developed in the European Court. So subsection 3 says, any questions to the validity, meaning or effect of any retained EU law is to decide as so far as that law is unmodified on or after exit day, and as so far as they're relevant to it, in accordance with any retained case law, any retained general principles, and having regard to the limits immediately before exit day of EU competencies. And then it says in subsection 4, the Supreme Court is not bound by any retained EU case law. That retained EU case law is case law before exit. And at subsection 5, the Supreme Court must apply the same tests as it would apply in deciding whether to depart from the case law. And of course, that has been extended to the Court of Appeal by the regulation, which you'll find rather strangely split between tab 22 and tab 23, the bundle. So the Court of Appeal is a relevant court. A relevant court is subsection 4 is not bound by a retained EU case law except as provided in paragraph 2. Paragraph 2 is a slightly convoluted provision. I think what it's saying is, if there has been a decision of a court that bounds this court, so for instance, if the Supreme Court had decided something on retained EU case law, you would still be bound by that, and you couldn't depart from that. What you can depart from is decisions of the European Court. And you are to apply the same test as the Supreme Court would apply in deciding whether to depart from the case law of the Supreme Court. And if this issue arises, we would say it would be appropriate to do that for 2 reasons, at least 2 reasons. One is, we would say in those circumstances, Phillips is impeding the proper development of the law in an area where thinking has moved on. And we would suggest that there is a possible analogy in a domestic situation with a, let's imagine a decision of the House of Lords in the past, and then there is subsequently, perhaps a number of years later, a decision of the Privy Council, which says it doesn't follow that in an area where English law is stated to be the same as the law of the country from which the appeal came. In those circumstances, that would be an appropriate case where the Supreme Court might depart from the House of Lords' previous decision. Although it's not bound by the Privy Council case, it would be highly persuasive. So that kind of situation could theoretically at least arise domestically. Can I just take you briefly then to the most recent case perhaps where the principles departing from a previous decision have been set out, and that's the FII decision. I'm afraid it's extremely long. We only need to look at about 2-3 pages of it. The background to this is decisions on the Limitation Act. I'm sorry, it's tab 95, and the page we're looking at is 1674, if you're able to. That's where they deal with the practice statement. So the background to this were a couple of decisions of the House of Lords on section 32(1)(c) of the Limitation Act, which defers the starting of the limitation period until someone has discovered, or could with reasonable diligence have discovered, their mistake. And put simply, the House of Lords in Deutsche Morgan Grenfell had decided that that meant, in essence, you had to know that you'd made a mistake, which could only really at practice arise when the court had ruled that you'd made a mistake of law, what the law was. And it's that decision which the Supreme Court overruled, departed from in this case, and applied principles which apply to other limitation provisions, which didn't have that stringency. But this is their discussion then as to why they would depart from it. There was another issue in the case, which was whether they should depart from Kleinwort-Benson in deciding that 32(1)(c) applied to mistakes of law at all. Yeah. And in fact, the minority, there's 3, decided that they should, Lord Briggs and Sales and Carnwath, but the majority decided that they wouldn't depart from that, but they would, that everyone agreed that they would depart from Deutsche Morgan Grenfell's approach. And it's particularly...
I'm so sorry, I didn't get the paragraph reference.
Right, it begins at 244 on page 1674.
Thank you.
My lady. Sorry, yes, it's a very long read. And it's particularly paragraphs 245 and 246. Thereafter, they're really considering it in the context of that particular case, which perhaps is not particularly helpful. But here they state that there is a public interest in the certainty of the law. On the other hand, where there were decisions which were impeding the proper development of the law, which led to results which were unjust or contrary to public policy, some situations, such as a fundamental change in circumstances or where a decision had resulted in unforeseen serious injustice, have been recognised as permitting a departure from precedent. We would say that's the situation here. If you were to conclude that the only barrier to applying NN was one that Phillips was binding, then we would say that would be impeding the proper development of the law and producing results that have now been seen to be contrary to public policy. this is a slightly strange case because, as we've seen, there is a line of authority in the European Court which is what was followed in NN. It's only Phillips really that is the exception to all of this. So it's not like that we've got a line of authority that we'd be asking you to overrule. We'd be asking you simply to overrule one case, which is an outlier.
I suppose it's perhaps a little unlikely we're going to get to this point, because if we're with you on the facts, on your argument that Phillips is an outlier, then that on the whole leaves it, one would hope, not too difficult to conclude that the law had developed in the CJEU's own terms in NN.
Yes.
And it's only if we, so in that point, if we come to that conclusion, I emphasize totally hypothetically, then it, of course, there's no need to go on to all the problems posed by Section 6.
Yes, and you are, of course, bound equally by NN for whatever it decides.
Yes. Yes.
Equally. So the question then is, well, how do you resolve that? And normally, I think as your Lordship indicated, you would follow the later case, because the later case has, of course, considered the earlier case in coming to its conclusion. So that would be the normal approach.
I mean, particularly in a system which doesn't apply the sort of Anglo-Saxon doctrine of precedent.
Yes. Yeah. So I'm only making these points. We only make these points as a fallback.
I quite understand why. I'm just.
Yes.
But
yes.
Yeah, but it's just it may be in practical terms it's not a very plausible scenario for us to end up in.
Well, I'm afraid there may be another. I mean, if you do have to get to this, there may be another point that you have to decide, because the point has been raised.
Well, exactly. There are all sorts of points made.
Very important.
Sure. Yes.
Potentially important points of principle, which certainly in other cases it could be important, if not in this one, which is that it only applies essentially to facts occurring after exit. Now, we say that there's no warrant in the legislation for that restriction. It's quite general. It would defeat the purpose of the legislation, we would say, if that restriction were to be imposed, because it would mean, as I've indicated, in cases where you were dealing with facts which occurred before exit day, you would simply be bound by any decision of the European Court, even if subsequent to exit day there was a whole series of cases which said that was wrong. Because they would only be persuasive, so you would be bound by the previous decision. And so you would be the court would be completely stymied.
Do we get any help from the commencement provisions for the Withdrawal Act? Or is that not?
I don't think so, no. But there isn't any, as we can see, there isn't any indication anywhere that this is to be limited. The only...
That's the famous presumption against retrospectivity.
Yes, but only, in a sense, this is not... It's retrospective in one sense, but it's it's not really retrospective, because it's the question of whether the courts can take account of potentially subsequent decisions of the European Court, and then make up its own mind as to whether to follow a case. I mean, the whole point of the Brexit is to give the powers back to the UK courts. So the UK courts have to now make the decisions, and that's the policy, and they have to make decisions in relation to cases where the facts occurred before exit day just as much as when they occurred after.
I suppose one possible approach is to say, well, we apply the declaratory theory, and this is a question about remedies, and so we're simply saying what the law always said.
Yes.
I'm just throwing that out. I haven't really
well,
thought it through.
yes, and I mean,
well, to your point about if you say one of the primary purposes is to allow the UK to take account of developments in EU law post-exit day that might affect earlier decisions, those further developments are on the declaratory basis saying what EU law always was.
yes, but without this provision,
you wouldn't be able to take account. You're saying you wouldn't be able to take account.
You take account of them, but They wouldn't overcome the
They
binding
couldn't-
effect of the
exactly,
previous decisions.
yeah.
Yes.
even though they were declaratory.
Yes. If there hadn't been a binding decision previously, then of course you could follow them, which you could take account of them. But I think you would be stuck if there was a binding decision prior to exit day. So this point has never been addressed in any decision, as far as we're aware. The taxpayers rely on a case called Tunin, which you will have seen.
It's not, the point's not, as I recall, the point isn't discussed there, is it?
It isn't discussed. It's a concession, essentially, by counsel for the claimants in that case. What they were asking the court to do in that case...
Which tab?
Sorry, it's in that, sorry. It's in tab 96.
Thank you.
Of it's bundle 7. I'm sorry, again, it's quite a long decision because it concerned a company which gave access to consumers to, I think it was something like 70,000 radio stations around the world, and allowed them to listen to music, and they could search it, and they could. I imagine if you searched up something like the Beatles, they would be playing somewhere in the world, any point, day or night. So you could probably find it. And there was various aspects to it, and the question was whether it infringed the copyright of Warner, who seemed to own about almost half of the copyright in the entire music market, according to this. And one of the questions was whether, communication, whether there was communication to the public when the public did this, listened to the radio stations, within Section 20 of the Copyright Designs and Patents Act, 1983, which was itself transposing an EU directive. And there had been 26 CGA EU decisions on that provision, on those ones, including 24 of which were pre-exit. And they are in fact set out by Lord Justice Arnold in his judgment. They take up an entire page of his judgment. Is it 17? Sorry. Sorry, I'll find it. Yes, page 1715. If you look at that, the entire page is filled with the case law on the meaning of communications to the public. And the claimant in that case were asking the Court of Appeal to overrule essentially most of these cases and come to a completely different approach. So it was a bold submission, which was rejected. And it may be in that context that counsel for the claimant made the concession, which is recorded by the Court of Appeal, although they make no comment on it, that it would only apply after exit day, the overruling.
Yes, so this looks like a big ask, but it's not quite as big as it looks.
Yes, yes, exactly, that's right.
Okay.
It was also, the Master of the Rolls described the argument as half-hearted and inadequately thought through. And they rejected it for a number of reasons. Interestingly, they quote, if you go to page 1749, the Master of the Rolls quotes on paragraph 199, the passage that I've taken you to, when the earlier ones were generally thought to be impeding the proper development of the law, results were unjust or contrary to public policy. He didn't think that was the case here. So the most that can be said about that is it was a submission by counsel which was recorded by the Court of Appeal, but no consideration was given to it. There are two other cases which we have set out in our skeleton that are in the bundle. Again, the point was not argued and wasn't an issue, but in both of these cases, the facts occurred before exit day, and the court was considering, at least, although it didn't in either case, overruling the previous authorities. And the first case is Lipton and BA City Flyer, and that's in fact in, I'm afraid, in bundle 6. Tab 93. And the question in this case was whether illness of crew was an extraordinary circumstance within the EU regulation. The answer was no. But you can see from page 1529, paragraph 5, that the events took place in 2018. In this case, it was recorded. Again, it certainly was not an issue in the case, but it was recorded by the Court of Appeal that it would be open, amongst other things, for the court to depart from previous decisions. But I don't suggest that it's any authority, because it simply is not. It's simply assumed by everyone that power would apply without any argument. And the other one is Chiluri and Air India. Where this was a question about what was a journey and what was the extent of a journey for the purposes of EU regulations. You had to be departing from an airport located in the territory of a member state to fall within the regulation. This particular journey was from the US to India via Heathrow, and the question was whether that fell within it. I think the answer was no, it didn't. You had to look at the whole of you had to look at the whole of the journey. You weren't departing from an airport. Although you did actually depart from the Heathrow at one point, that wasn't what the regulations meant. The facts in this case all occurred in 2019. You can see from paragraph 5. And again, it wasn't an issue in the case, it wasn't in any sense decided, but it was recorded, assumed that there was a power to depart from previous decisions. But there was no question of that happening in this case. If you look at paragraph, look at page 1566. It was being argued that a case called Wegener was wrong, and that they should depart from it. And interestingly, in paragraph 61, you can see that Tunin was cited. For the proposition that they could depart from previous decisions, interestingly. So no one, including the Master of the Rolls, who was actually one of the constitution in Tunin.
Sorry,
Nobody.
Which paragraph is that?
I'm sorry, paragraph 61.
61.
I mean, perhaps I'm missing something, but at the moment it seems to be a natural assumption to make. I mean, the point about departing from a previous case is if it establishes some principle of law which turns out to be questionable, and you want to be able to say it therefore shouldn't be followed in the future. But why that principle should apply any differently just because of the date when the facts took place doesn't make any sense to me at all.
No, I agree, and there is nothing, as I said, in the legislation.
No.
But there is no.
So where does this
I think it only comes from the. Well, it's my understanding. Yeah. It only comes from the statement, the recording of the submission in Tunin.
That's all. Yeah.
I think so. I haven't been able to find anything else. Yeah. I don't think anything else is relied on. Just interestingly, you might want to look at what Lord Justice Coulson said in paragraph 62, where he was considering whether he should depart. You can see no principal basis to depart from the decision in Wegener. There has been no change in any relevant piece of legislation and no recent authority which could justify the separate treatment of the component legs. So he's looking at whether one of the things he's looking at is whether there has been recent authority. Wegener has been repeatedly followed and referred to in the CJEU's subsequent cases. So that's we would say is almost the converse of the situation.
So it's part of the settled case law of the court.
It's part of the settled case law, yes. And I can then turn. I think I can deal with this fairly briefly because we only rely on this aspect of the case what was said in NN in the court. Our cross appeal of objective comparability. So if we could take you to NN. And it is it's what they say on page 908 of the bundle. So they start with the proposition that the comparability of cross-border situation with an internal situation must be examined having regard to the objective pursued by the national provision at issue. And then they say in the present case it's apparent both from the terms of paragraph 31.2.2 and from the explanations provided by the Danish government related to that provision that the objective of the provision is to prevent the double deduction of losses. And I say that's the same in the present case for the reasons I gave earlier. Then they say the court has held that with regard to measures laid down by member state in order to prevent or mitigate the double taxation of a resident company's profits, companies which have a permanent establishment in another member state are not in principle in a situation comparable to that of companies which have a resident permanent establishment, and that's Beveler, which you have seen. So the court then reasons by analogy with Beveler. The view must therefore be taken as regards the measures intended to prevent the double deduction of losses, that a group whose non-resident subsidiary has a resident establishment is also not in a situation comparable to that of a group whose subsidiary and the latter's parent establishment are also resident. And that's because we would say the former it is possible for the former, potentially can deduct losses twice, while the latter cannot. 35. It's nevertheless important to make an exception for the situation in which there is no other possibility of deducting the losses of the non-resident subsidiary attributable to the permanent establishment, which is resident in the member state in which the subsidiary is established. In that situation, the group whose subsidiary is situated in another member state is not in a different situation to that of the purely national group in the light of the objective of preventing the double deduction of its losses. That's because there isn't a possibility of double deduction, because there isn't a possibility of deduction in one of the states. The tax-paying capacity of the two groups is then affected in the same way by the losses of the resident permanent establishment. But that is in that particular situation. Admittedly, paragraph 31.2.2 of the law on corporation tax removes the difference in treatment if the rules in the foreign state in which the company is resident provide that the loss cannot be set off by accepting, in that case, that the losses of the resident permanent establishment of the non-resident subsidiary may be set off against the group's income. So that's a point about the actual position in Denmark. However, it cannot be excluded that such a deduction, even when permitted by the legislation of the foreign state, may not be possible in practice, particularly in the case where the non-resident subsidiary has definitely ceased all activity. So there they're drawing a distinction between the theoretical right to deduct in the other state, which seems to be what the Danish law is talking about on their interpretation of it, and whether it is possible in practice to deduct, which is the factual question. And therefore, they say the difference in treatment mentioned may, at least in that case, that is the case mentioned in paragraph 37, concern objectively comparable situations. And that's why they go on to consider justification. So we say that, I think it goes back to the debate that you were having, my learned friend, about the level of generality at which you look at the national provisions at issue. What we would say the court is looking at here is the provisions in relation to losses, specifically. And the double deduction of the losses. So it is comparing the cross-border system with the internal situation in the light of that consideration. And it says in the light of that, they're not in a comparable situation. That is paragraph 34. So we say because, for the obvious reason that in one situation, double use of losses is possible, and in the other it's not. So we would submit that's the reasoning of the court in NN. Now, it's clearly not the reasoning of the court in Phillips, because Phillips came to a different conclusion and looked at the legislation more widely and said essentially said the permanent looked at the permanent establishment, I think it's right to say, and said, well, that is taxed in the same way as a UK company, and therefore they're in a comparable situation. Whereas the court in this case seems to have been looking at more broadly, if you like, at the group situation, and not just at the particular position of the permanent establishment. So we would say, except in a situation where it's not possible in practice to use the losses at all in one of the member states where there isn't a danger of double deductibility, that these two situations are not comparable. Now, it is, again, you are faced with the problem that you have two decisions. If I'm right, if I'm right, you have two decisions of the European Court on the issue of comparability, which are both binding on this court.
Yeah, but Phillips, for what it's worth, purports to do so by reference to this specific provision and identifies the objective in a different way.
Yes.
To NN.
Yes, but yeah. But if the NN approach is correct, then there's nothing that distinguishes the two systems.
But does it not need to be tied to the particular difference in treatment identified? So in Phillips, as we know, it was between branch and subsidiary, foreign company establishing either branch or subsidiary. Here, the difference in treatment was a different one. Is that difficult? I know that the paragraphs you've taken us to don't
refer to
quite tie it in that way, but it is maybe tied in at least by what precedes it.
Yes.
Because you have to, the starting point is the difference in treatment, isn't it? So what do you say to that?
I'm not sure. There, in a sense, really there are two separate questions, aren't there? Is there a difference in treatment between these two situations?
Yes, but you need to know what you're comparing.
Yes, no.
Comparable. So
I understand that.
I think that's the question I'm asking.
Yes. And in our case, you are comparing a situation where one might say there's there's different ways that you can compare it, I suppose, depending on what restriction you're looking at.
But the taxpayer is choosing to use a different.
That goes back to the question again. Yes. You're comparing the situation of, on one view, you're comparing the situation of a domestic group and a foreign company. Well,
that's the way you would obviously prefer, HMRC would prefer to see it, and I can see your reasoning. But that's not the way it's being presented. Yeah. Or the complaint is made.
Yes. There's another difference in treatment between, a situation of the foreign company establishing a subsidiary as opposed to a branch. Yes. And I guess that is a question of whether you can choose.
Well, did we get any help from from any of the cases about how you go about making the comparison?
I don't think so. They simply move on. Usually they move on from. Usually, difference in treatment is pretty obvious because there's clearly a difference in treatment. Otherwise, they wouldn't be there. But they move on into comparability, and I mean, it may depend to some extent on what it means by having regard to the objective pursued by the national provisions at issue. Because if you look more broadly, whatever difference in treatment that they are identifying, there still is no necessarily comparability between the domestic situation and the foreign situation. But I quite take you.
Yeah, I mean, if the position is, and I suspect you're right about this, that there is no real help in the cases on how one should make the comparison, that rather strengthens the argument that we, on the face of it, we were stuck with Phillips on this point, because that was a decision bang on point by a court whose decisions are now at one remove still binding on us.
Yes, unless you think
Unless
you want to
think,
depart from it because you think it's a wrong.
I mean, this is your siren song, of course, but but given the difficulty of identifying the right criteria for departing, maybe here the safer course is to stick with the devil we know rather than.
Well.
Anyway, that's what we'll have to puzzle with.
That's what we have to. Yes, I think that's right. So I think that probably deals with, unless there's anything further than that, deals with the cross appeal. So I have no further submissions unless the court would like to.
No. All right. Thank you very much.
Thank you.
Yes, I'm sure.
So I'm going to deal with the issues in my reply and response in the order that we set out in our agreed list, if that's convenient.
Very convenient.
So starting then with issue 1. So my learner friend spent most of yesterday taking you through the various cases to establish the proposition that double deduction of losses is now recognised by the court as a standalone justification. And we say that that is certainly the case where the freedom of establishment in issue is that of a resident company to establish itself in another member state. In other words, in a home state case, NN is authority for that proposition that double deduction of losses is a standalone justification. But none of the cases that we looked at yesterday contain any indication that the double deduction of losses must necessarily also be regarded as a justification in a case of host state discrimination. So if I can briefly take you back to these decisions to show you that the way in which the court discusses the issue of the justification and the double deduction of losses is by reference to, or in the context of, the specific discrimination in issue. So moving, I hope quite quickly, if we can start in volume 2, behind tab 46 is Little Belgium, and the relevant paragraph is on page 548, paragraph 37. So if I can ask you just to read paragraph 37 to yourselves. So in our submission, what you have to do is read the whole of the sentence. You can't just stop at the point where the court says justifying a restriction on the freedom of establishment, full stop. What the court is doing is going on to explain when it is capable of justifying restriction on the freedom of establishment. In other words, when it arises from tax treatment by the member state in which the seat of a company is located of losses incurred by a PE situated in another member state. That is the situation in which the court has accepted double deduction of losses as a justification. In volume 3, tab 56, the case of A. Oy, we make the same point in relation to paragraph 46, page 675.
sorry, 675.
It's 675, yeah, paragraph 46.
Thank you.
So again, the same point, the court's endorsement of the justification is explicitly tied to the particular situation in issue, which we describe as home state discrimination. In volume 4, we have Beveler behind tab 71. And in that case, it's paragraph 52 on page 887. Again, the court's reasoning is tied to a restriction on the freedom of establishment, such as that at issue in the present case, which was another home state case. Now, can I also take you back, please, to Ores, the AG in Ores, which is behind tab 80. We looked at page 1002, paragraphs 46 to 49, for the proposition that now even Advocate General Cocotte accepts the double deduction of losses as an independent justification. We say what she's actually saying in these paragraphs is that double deduction of losses has been accepted as a justification since M&S.
Sorry, this is 46 to
46 to 49, yeah. We looked at those paragraphs yesterday. And in our submission, what she's actually saying there is double deduction of losses has been accepted as a justification since M&S, and that's obviously correct. And that a deduction of foreign losses runs the risk of double deduction. So she is again tying her reasoning to those home state cases involving deduction of foreign losses. So her comments have to be viewed in that context, which is the context of home state discrimination. And just pausing there for a moment, my Lady Justice Falk asked a question yesterday about whether Ores could be regarded as a host state case. And very loosely, Ores can be regarded as a host state case, but it's not a conventional host state case because it's a host state in which the host state was permitted to discriminate because it didn't have taxing powers over the company in question, the establishment in question, at the time the losses were incurred.
This is the Czech one.
Exactly, yeah. It's the Dutch company transferring to the Czech Republic. Prior to that transfer, the Dutch company generated losses in the Netherlands. The question was whether it essentially could import those losses. And the reason why the Czech Republic was allowed to discriminate in that case is because it didn't, at the material time, it wasn't the host state. It wasn't even in the picture at the material time. So that was why, in that situation, there was no objective comparability. And you can see that if you briefly turn up tab 81, page 1011, and you can see that in the court's judgment at 41. So even if it's right to regard Ores as a host state case, it's consistent with the reasoning in Phillips, which is that the host state's taxing rights are absolutely central to the analysis. And then finally, if we can return to NN, which is tab 73. Again, we say that the court's endorsement of the double deduction of losses here is, again, explicitly tied to the particular difference of treatment which arose in that case. And you can see that in particular in paragraphs 39 and 48. The referring court asks whether that difference in treatment could be justified by the objective of ensuring a balanced distribution of powers of taxation between the member states, or by that of preventing the double deduction of losses. And then in 48, it concludes the difference in treatment established by national legislation thus appears to be justified. So their analysis is tied into that, to its earlier conclusion as to the nature, the specific nature of the difference in treatment in that case. So we say that the developments in the court's case law only take us so far. It only tells us that as regards home state discrimination, it is permitted for a home state to discriminate against non-resident companies on the basis of preventing the double deduction of losses. But in our submission, that doesn't take us far enough, because in circumstances where the court's reasoning has been deliberately, we say, and explicitly tied to the particular situation at issue, namely the home state discrimination in issue, it cannot reasonably be inferred from that that the answer would necessarily be the same in a host state case. And the question that you must ask yourself is, what is the current state of the law? And in our submission, the current state of the authorities, which we've now reviewed at great length, is that whereas a home state is generally permitted to discriminate as between a resident and non-resident entity on the grounds of preventing the double deduction of losses, a host state is not. And that is so even if the double deduction of losses is now regarded as a freestanding justification in its own right. And we know that that's the case because the court in Phillips at paragraph 28 says so in terms. Even if it is a freestanding objective, it cannot be relied upon by a host state. And the reason why that is the case is because in a host state case, there will always be a link between the losses and the UK's taxing rights. And that's what the court in Phillips explains at paragraph 31. By contrast, in a home state case, where the losses in question are foreign losses, there isn't any link between the losses and the home state's taxing rights. So the deduction of the losses in the home state will amount to true double deduction. And that is why in many of the home state cases, well, essentially with the exception of NN, you see the justification of double deduction of losses going hand in hand with the justification of preserving the balanced allocation of taxing rights, because they're both engaged where you're looking at the deduction of foreign losses in a home state case. The evolution, as I've explained, the evolution in the case law comes with NN, and what NN demonstrates is that the answer is the same in a home state case involving domestic losses, and so where the balanced allocation of taxing powers isn't engaged. But in that instance, it remains true, the general proposition that a home state is entitled to discriminate remains true and can be justified by the standalone justification of double deduction of losses. And the reason why that is the case is because, as the court explains in paragraph 48 of NN, if the position were otherwise, it would lead to the absurdity that a resident company routing a resident PE through a non-resident subsidiary was placed into a better position than a wholly resident group. So, in other words, if the court in NN had decided that a home state wasn't entitled to discriminate in circumstances where there's no issue of the balanced allocation of taxing rights, and so, in other words, if Denmark was required to disapply that provision of Danish law, the effect of that would be to place a Danish company with a non-resident subsidiary in a better position than a wholly Danish group, a wholly Danish counterpart. And so that is why home state discrimination is nonetheless permitted, even if you don't have a balanced allocation of taxing powers issue, by reference solely to the double deduction of losses. Now, by contrast with a host state such as this, the result of the host state not being entitled to discriminate on the basis of double deduction of losses, in other words, if you disapply section 403D1C, the result of that is to put a non-resident company in the same position as a resident company. And the consequence of that is that in some instances, the losses of the host establishment, whether it's a PE or a subsidiary, may be deductible against foreign profits. But what you are doing is regularising, equalising the positions of a UK PE of a non-resident company and a UK subsidiary of a non-resident company. So disapplying section 403D1C here simply puts a non-resident company with a UK PE into the same position as a non-resident company with a UK subsidiary. So for all those reasons, in our submission, on a proper reading of NN, it comes nowhere near departing from Phillips on the question of justification. On the current state of the law, the position with regard to host states is that set out in Phillips Electronics. And NN says nothing about the position, or says nothing that should be taken to have upset that conclusion. And so finally on this, the revenue described Phillips as an outlier, and we don't as such take issue with that. Phillips is an outlier in the sense that all of the other cases are concerned with home state discrimination. But describing Phillips as an outlier doesn't make it wrong. That doesn't in and of itself suggest that the decision is wrong. It simply tells you that it is a rarer instance. Ordinarily, the cases have concerned home state discrimination. So that's what we say about the state of the authorities. Our second point in reply concerns the worked examples that are in the revenues, at the back of the revenues skeleton. Can I just hand up just a reworking of those? So what we've done here is we've taken the revenues worked examples and we've annotated them, and that's the text in red is our annotation. Now, as far as the group relief example is concerned, the reason why the revenues example gives the wrong economic result, as they put it, is because it doesn't take account of the recapture mechanism. So what our amendment shows is that once the recapture mechanism is taken into account, then the right economic result, as the revenue would put it, is achieved across the 2 years. And then as far as the carry forward example, we say that the analysis is flawed because the taxable profit of the UK PE in year 2 is 50 and not 150. And therefore, once you make that change, the non-resident company pays 30 of tax in year 2.
Sorry, why do you say that's wrong? Can you explain?
So the UK taxable profits in year 2 are 50.
Yes.
So if you bring that into account for the non-resident company, so you treat the non-resident company has its own profits of 150. It brings into account 50 of UK profits. So it has total profits of 200. And then it pays tax of 30, which is 40 minus 10 of double tax relief.
I'm not sure I follow that.
So the revenue we're bringing into account, the UK PE's, if you like, profit before tax. So what the Dutch recapture mechanism does is it brings in UK
Sorry,
profits.
is this a recapture point again? The annotation.
Yes.
So I understood that the annotation on page 1 is a recapture point.
Yeah.
Does
This
the
is the position as it would be under the recapture.
Right,
so the
but it's a recapture point.
Yeah.
It's not saying that absent the recapture, the calculations were wrong.
Well, that's the position under a recapture. How much profit is brought in another member state will obviously depend on the particular rules in any other member state.
Well, yes, that's why I don't understand why it's bringing in a UK taxable profit in that column, but I'll have to look at it.
But from a recapture perspective, what the Dutch rules do is bring within the charge to Dutch tax the UK profits. So that's why it results in, well, it produces the
Yes,
wrong,
but
the
not
wrong
computed
result.
on a UK tax basis.
Sorry?
I don't think computed on a UK tax basis.
Possibly not on a UK
No.
tax basis, no.
Okay, but in any event, the main point is you're showing the effect of the recapture mechanism.
Yeah, and the other point to note is that from a UK tax position, everything's right. Everything is as you would expect. It's if you like, the differences arise because of the situation in the Netherlands. So that's what we say about the worked examples. So our third point in reply is that it's not enough for the revenue to contend that preventing the double deduction of losses is a legitimate objective in line with international tax policy. That only, again, we say, takes them so far. And indeed, that much is not in dispute. We accept, as I say, that the objective of preventing the double deduction of losses is a legitimate objective. The question with which we are grappling here, and which is the question that all of the cases are concerned with, is whether that objective is capable of justifying discrimination. And we say the case law has furnished us with the answer. In the case of a host state, it is not an objective capable of justifying discrimination. In the case of a home state, it is. So in our submission, simply pointing to the objective is not in and of itself sufficient. International tax policy doesn't go on to say, and feel free to adopt whatever measures you like in the pursuit of that objective. So there is no issue with the objective itself, and indeed, if the UK hadn't discriminated, if the UK had introduced an equivalent measure for UK companies, we wouldn't be here. The issue is whether the objective can justify discrimination, and that is not, as we say, a matter on which international tax policy has touched. And we say if the consequence of the UK's failure to fulfil its treaty obligations is that Section 403D1C must be disapplied because it creates discrimination, and the losses are then available for group relief in the UK, as well as being deductible in the Netherlands, then that is simply the consequence. Because if it were otherwise, then the freedom of establishment is meaningless. The purpose of the freedom of establishment is to ensure that non-resident entities are able to operate in a member state under the same conditions as resident entities. And if the upshot of the UK failing to fulfil its obligations in that regard is that there is simply no remedy, then in our submission, the freedom is toothless, and that cannot be right. So to address your discomfort head on, why should the losses of a UK PE of a non-resident company be available for group relief if they are deductible overseas? The answer is because that is the position for UK companies. So where UK law allows group relief for the losses of a UK subsidiary of a non-resident company, even if they're deductible overseas, it must extend that same treatment for UK PEs of non-resident companies. So whilst the UK can set the rules, and it's perfectly entitled to say no group relief where losses are deductible overseas, it must apply those rules equally. And if it's okay for a UK subsidiary of a non-resident company to group relieve its losses, even though that would amount to double deduction, then the same must be true for a UK PE of a non-resident company. What the UK cannot do, which is what it's done here, is pick and choose. So that's what we say about issue 1. On issue 2, the question of proportionality, we say that even if 403D1C can properly be interpreted as the revenues say, essentially in line with the M&S criteria, then it remains disproportionate in 2 respects. Firstly, by disqualifying all the losses where only part of the losses are deductible, and that scenario might arise in a situation which my Lady Justice Falk identified a moment ago, which is where you have different rules for computing deductible losses. So in the UK, you might get a deduction for depreciation, say, and in another member state, you might not. So actually, the losses are, you've got an element of the losses which is not deductible on non-resident rules, and yet all of the UK losses would be disqualified under 403D1C. And the second way in which it remains disproportionate is by precluding the surrender of losses which are only temporarily deductible elsewhere by virtue of the existence of a recapture mechanism. Now, I think we briefly touched on the authority of K, but it's something that features in the revenue skeleton at 33, and where they rely on K as authority for the proposition that the UK cannot be required to adapt its rules depending on the particular proclivities of another tax system. And in our submission, K is not authority for that proposition. So the issue in K was whether Finland, as the home state, was required to give tax relief for French losses in circumstances where there was no relief in France for those losses. And the answer was no, because if it were otherwise, then Finland would effectively be being required to make good an adverse tax result arising as a result of the French rules. And we say that that is very different to the present case, where here the UK is the host state, and essentially it's seeking to rely on a benefit that is extended under the Dutch rules as a means of justifying its discrimination. So we say that even if you can properly interpret 403D in the way that the revenue suggests, it remains disproportionate in those two senses. So then, moving on to issue 3. So on the question of conforming interpretation, we make the same criticism of the revenues case as we make of the Upper Tribunal, namely that when examining the grain of the legislation, they're taking too high level of an approach. So the revenues contention is that the conforming interpretation proposed by the Upper Tribunal is consistent with the grain of the legislation, because all it does is to identify a more limited subset of foreign loss cases. And we say that whilst in general terms, Section 403D1C is of course concerned with losses incurred by UK PEs of non-resident companies, but that again only takes you so far. The point, as Sir Andrew Morritt explains in Vodafone 2, is that the grain of the legislation has to be identified by reference to its fundamental or cardinal features. And as we've already submitted, the fundamental or cardinal features of Section 403D1C, which is the point made by the AG in Phillips and also the point made by the UK in its response to the Commission, is that it is concerned with possibilities of use. It is a no possibilities test, rather than with actual deductions. So turning then to issue 4, in response, we say that on the question of whether NN should be taken to have overruled Phillips on objective comparability, we say the answer is obviously no. We say that self-evidently the question of objective comparability depends on the comparison in issue. And in NN, the comparison identified by the court was between a wholly Danish group and a Danish group with a non-resident subsidiary with a Danish PE. And it's quite obvious that the reasoning in NN is tied into that specific comparison, because the court says in paragraph 38, thus the difference in treatment mentioned in paragraph 29 of the present judgment may, at least in that case, concern objectively comparable situations. So it's quite clear that the court is focused on the specific difference of treatment that it had previously identified when answering the question of objective comparability. By contrast, in Phillips, the comparison identified by the court, it's paragraph 15, was between a non-resident company with a resident PE and a resident company. And the question that the court asked itself was whether that difference in treatment concerned objectively comparable situations, and that's paragraphs 17 and 19 of the judgment in Phillips. So on the basis that each case was concerned explicitly with different comparators, it is not in our system tenable to suggest that NN has overruled Phillips in that regard. And in particular, we say it is not enough for the revenue to simply point to the purpose of the provisions and say, well, the purpose is the same and therefore the answer must be the same. The purpose of the provisions doesn't, in and of itself, provide the answer. The purpose of the provision is a factor to bear in mind when undertaking the assessment of comparability between the two situations which have been specifically identified. So we say nothing in the court's reasoning in NN undermines the court's analysis in Phillips, and indeed the reason why in a host state case the situation of a non-resident company with a UK PE and a resident company are objectively comparable is because, as the court explains in paragraph 19, that it enjoys the same taxing rights in respect of the UK activities of both. And we say that specifically in the circumstances of this case, the UK can be taken to have accepted the objective comparability of a non-resident company with a UK PE and a resident company when, as regards the taxation of their UK profits, and in all other regards, the UK is prepared to treat those two in the same way. And that is the point that is made by the AG in Phillips at paragraph 36, which you'll recall is echoed by the court in Beveler at paragraph 34. So if that is the treatment which the UK
Sorry,
has
Beveler
at 34.
By the court?
By the court, yeah. So if the UK treats the two the same for the purposes of taxing its UK activities, it can be taken to have accepted the objective comparability of those two entities as regards the use of their losses. So that's why we say that NN cannot properly be taken to have overruled Phillips on the question of objective comparability. And then I'm about to move on to issue 5, which is your power under section 6, which I don't think I will finish in 5 minutes. I'm happy to press on, but I won't be very long, but you might want to have a sort of clean run at it if you like.
Yes, and I mean, we seem to be well on track to finish, so, well, if yes, why don't we stop now? Can I just mention the question of temperature? The usher passed me a note asking whether he could open the window, and I said yes because I was feeling quite hot. I just wanted to check whether people are comfortable with the window open.
I'd be grateful for
it
that.
was getting very hot. So I think we can all record our thanks to the usher. Thank you very much indeed for opening the window. We're very grateful. I mean, let's keep an eye on it as the afternoon goes on. If people get too cold, please don't hesitate to mention it, and we'll ask the usher to very kindly shut it again.
Thank you.
Right, well, let's say 2 o'clock, please.
All rise.